Now I present Professor Bill Marshall, the Keenan Professor of Law at University of North Carolina School of Law. Welcome, Bill.
Hi, thanks. Thanks and greetings from Chapel Hill. By the way, if any of you see a disconnect between the audio and the visual here, that's not your technology, that's actually how I speak. My chapter here today is on constitutional interpretation, and certainly unlike the big debates over gay marriage or healthcare, no two words so excite the soul than constitutional interpretation. Now, seriously, I understand, maybe not, but constitutional interpretation provides the foundation as to how all of these other decisions actually get decided, and in that sense, it's critically important. And as you know, the debate over constitutional interpretation is really in two camps right now. On one side, you see the originalists who argue that the meaning of the Constitution should be interpreted in accord with its original understanding, how the words were understood at the time of the framing, versus what's set forth in constitutional faith, meaning that the Constitution should be interpreted with the understanding that while the principles enshrined in the Constitution do not change over time, the application of those principles must evolve as society changes and as experience informs our understanding. The debate between liberals and conservatives was not always framed this way. Originalism is relatively new. It sounds old. It's relatively new. It's really only a 30-year intellectual movement that was begun by Justice Scalia, Edwin Meese, and Robert Bork. Prior to that time, the predominant conservative realm of thought was calling for judicial restraint. In reaction to a number of decisions of the Warren Court, which struck down certain laws that conservatives did not believe should be struck down, they suggested that the court should not interfere with majoritarian action by elected political bodies. And some conservatives still believe this. Judge Wilkinson, the Fourth Circuit, Judge Posner of the Seventh Circuit, for example, are leading proponents of judicial restraint. But the originalism moves on, in part because the conservatives have consolidated their power, and in part because of much of their agenda is to strike down laws on such topics as campaign finance, property rights, affirmative action, and now, of course, health care. But regardless of what the underlying agenda might be here, originalism is a theory that deserves to be taken seriously. There are three intellectual arguments that are often advanced to support originalism. The first is that this is what the framers wanted. There are problems with that, however. First of all, the framers put in the Constitution deliberately ambiguous text. Words like due process of law, equal protection of the law, freedom of speech. None of these terms have really set defined meanings. So the notion that we should look back to an original meaning that really didn't exist with any precision doesn't really work. Second of all, the framers were common law lawyers. They came from a tradition which understood that the application of enduring principles would change over time, and there's no reason to believe that they would have felt that a constitution should be interpreted differently than that. They understood that law needs to be contextualized in the time that it's in. And third, and perhaps most important, the framers were visionaries. They did not adopt the Constitution to respond to short-term problems. They adopted it to endure over the long haul. And I think the originalist account actually does injustice to the brilliance of the framers by suggesting that they were more short-sighted than they actually were. Second, originalism has been defended as what is necessary to adhere to the rule of law. But again, that's not right. Common law principles change. Law has always understood that there has to be some change in applications, even if the enduring principles stay the same over time. This is what John Marshall meant when he said in McCulloch versus Maryland, it is a constitution that we are expounding. This is not an abandonment of the rule of law. This is an implementation of the rule of law. And the third argument behind originalism is that it cabins judicial decision-making. Well, this is wrong both intellectually and laughably, it turns out, in its application. First of all, again, it's hard to cabin judicial decision-making when so many of the words, such as due process of law or equal protection of the law, are so vague. And in any event, the historical record is incomplete. It's difficult to understand if there was any consensus behind the meaning of specific terms. The framers, for example, were very politically diverse. Patrick Henry and James Madison agreed as much then as Nancy Pelosi and John Boehner do today. And now we get to the laughable part, when it is argued that originalism actually constrains judges. It certainly didn't in Citizens United when the court held that corporations had a First Amendment right to spend unlimited funds to try to influence elections. The framers of the Constitution did not like corporations. Corporations at the time were on very, very limited leashes, very close charters. There's no real originalist argument in favor of Citizens United, nor is there one in favor of the conservatives' attack on federal affirmative action. The Fifth Amendment doesn't even apply to the federal government. Not only that, there were a series of programs during that period that specifically helped African Americans and not whites. The governing rule of originalism in its application is that it's used by the court every time in every possible case except when they don't do it. And they often don't do it in the same way that they do it as an effort to reach conservative results. On the other hand, we've got the theory of constitutional faith. Again, the basic principle here is that the constitutional principles stay the same, but their application may change over time. This, I believe, really reflects the framers' vision. This is what they wanted to do when they set up a constitution. This also means, as Pamela Karlan and Chris Schrader and now California Justice Goodwin Liu argue, that this allows the Constitution to keep its legitimacy by not becoming obsolete. And if you take a look at the historical record, it is this kind of constitutional interpretation that has led to the decisions that fulfill the framers' vision. Many of our most important cases cannot fit within an originalist understanding, but they represent what are considered to be core constitutional values. This includes the principle of one person, one vote, the decision in Brown versus Board of Education striking down de jure discrimination, the right to counsel recognized in Gideon versus Wainwright, the right to privacy recognized in Griswold, the protection of the rights of women in the Virginia military case. All of these cases could not have been decided the way they were on originalist grounds, yet all represent faithful adherence to the long-term principles that underlie the constitutional document. Now, one question does come up. Is there a cabining principle to the courts deciding what are these non-enduring principles and how they are to apply in a given context? And I think the answer is yes, and I think that was set forth in Caroline Products, that the court should generally defer to the decisions of the elected branches. That's what a democracy is all about. But they should interfere. They should look carefully at laws that affect the legitimacy of the political process themselves. Those, for example, that single out minorities who are often unable to protect themselves through the political process, or those that regulate the mechanics of the political process itself, such as freedom of speech or voting rights cases, etc. Now let me quickly give you some specific examples of how originalism and what we're calling constitutional faith might differ. Some Pamela Karlan referred to last week in her lecture. She talked about thermal imaging. Madison didn't say very much on thermal imaging, yet the notion of a search and seizure, of an invasive search by the police, applies when the police are across the road holding a device that can tell where heat is in the house just as much as when they go through the door and actually invade property space. Very little was said by Jefferson on free speech on the internet, or by Gouverneur Morris and free speech on cable TV. And yet allowing the law to accommodate these new technologies makes sense. That's what the First Amendment should be about. But it's not just accommodating cultural change. It's also accommodating changes in cultural meaning. The meaning of the right to vote and equality in the right to vote is very different when there is universal suffrage, as there is now, than when only white property men had the right to vote. So now the notion of one person, one vote, which by the way is not in the Constitution. It's not even in your ACS copy of the Constitution. That decision that comes out of Reynolds versus Sims makes a lot of sense now when everybody has the right to vote in a way that it didn't when the Constitution was originally enacted. Or consider one of my favorite cases of all time, West Virginia Board of Education versus Barnett, which held under the Free Speech Clause that the Jehovah's Witnesses could not be compelled to salute the flag and recite the Pledge of Allegiance in the public schools. Barnett is rightly celebrated as one of the greatest First Amendment decisions in American history, and it's clearly one of the most courageous given that it was decided at the height of World War II. But it cannot be defended on originalist grounds. Compelled speech was not prohibited during the founding era when the First Amendment was enacted, nor during the post-Civil War years when the 14th Amendment was enacted. And the text of the First Amendment says nothing about the right to speak, the right not to speak. But Barnett does exemplify progressive constitutionalism in that it shows how societal experience can lead to changes in how freedom of speech principles are understood. The idea that national unity is the basis of national security, which the court held just 3 years earlier in upholding compelled flag salutes in a different case, may seem innocuous as a justification for requiring school children to salute the flag. But this rationale takes on an entirely different connotation in the face of a war against a totalitarian regime. Against the background of Nazism, the reason why compelled flag salutes is such a threat to individual freedom becomes graphically clear. Accordingly, under this understanding, when Barnett strikes down compulsory flag salutes, even though an originalist would not do so, it is not rewriting the First Amendment. It is instead recognizing that the applications of the First Amendment must change to accommodate the lessons of history and through the experience of all of American citizens. This is what constitutional faith is all about, and this is exactly what originalism misses. So now let me take some questions. Thank you.
Thank you, Professor Marshall. We'll now move into the question and answer portion of this lecture series and start with a question how does a living constitution prevent judges from
effectuating their own political preferences would be my guess as to how that question
might beliefs into the Constitution?
Okay, yeah, terrific question. First of all, I don't like the term living constitution, nor do the authors of the book, because I think that improperly connotes something that's not there. The principles do stay the same. I mean, I think that's the essential point. The principle of freedom of speech is one that lasts over time. The question is, how precisely does it cabin judicial discretion? I think a lot. Not completely, but originalism doesn't either. Again, the term freedom of speech is subject to a lot of different interpretations. What the framers meant about freedom of speech is unclear at the time of the founding. They passed the many of the framers were in the Congress that passed the Alien and Sedition Act, which prohibited criticism of government. Does that mean we should interpret the First Amendment to not allow the criticism of government? Thomas Jefferson suspended the Alien and Sedition Act. Does it mean that we should follow Thomas Jefferson's lead and suggest that the Alien and Sedition Acts were unconstitutional? Originalism doesn't give us a direct answer, so there's going to be some discretion there as well. But I think the way we look at freedom of speech cases is look at what freedom of speech is designed to achieve, what the framers had in mind. And I think the court was right in New York Times versus Sullivan that what the framers had in mind was a robust, uninhibited discourse that would allow citizens to make political choices in order to allow the democracy to function, and therefore we should have a very broad understanding of freedom of speech. Does this give us a scientific roadmap in every case? No. But law doesn't do that. The common law doesn't do that. Constitutional law doesn't do that. But we have many tools at our disposal to limit judicial discretion. Precedent, text, history, and a deep understanding of the fundamental principles involved.
I had a question that I'd like to ask. Do you see any possible conflicts arising in the future? Any might arise dealing with originalism?
Sure. I mean, I think we're going to see all different kinds of issues arise. I mean, the internet, this kind of communication is changing our views on what privacy means. Privacy to the framers was a very personal spatial kind of concepts. Privacy in our day and time is something different. We're all over Facebook. We have different kinds of boundaries as to what our personal space should be that is not defined physically, but is defined in cyberspace. Originalism has no tools to be able to deal with the issues that are going to come out of cyberspace, free speech, privacy, and those kind of things. I think constitutional faith does, because we can look at the underlying principles involved in order to be able to decide some of these cases. With respect to health care, I think it's actually, I think the issue before the court at this point is not all that difficult. The decision not to buy health care insurance is a commerce-related decision, and I think the mandate will be upheld. But consider the notion of health care without any mandates. There's no question. I don't think anybody seriously says that if the government wanted to, it couldn't provide universal health care. The only constitutional issue involved here is the constitutionality of the individual mandate, and like I said, I think the better argument is that that does survive.
In your opinion, which of the current justices adhere to constitutionality fidelity, in parentheses, just the 4 liberals or others, question mark? And to the extent that those justices depart, do they do so in a consistent way?
The answer to the last question is easy. I don't think the liberals or the conservatives have kept a great deal of consistency in their approach. So gun rights to the states. And we can disagree as to whether or not the Second Amendment created gun rights or not. And I think one of the interesting things about Heller, which is that case, is that you can see how history can be used on both sides. I mean, both the majority and the dissent in that case literally wrote history books on whether or not the framers intended to write a Second Amendment right. But once that case is off the table, I think that it's pretty easy that if we're going to recognize that right, it should apply to the states. And I was very disappointed in the liberals in dissenting on that case, because the way they wrote the opinion made it sound like that they were rejecting much of the important decisions of the Warren Court, which did apply. With respect to who is the justice with the most constitutional fidelity, I think I want to go to one who just recently retired, and that would be David Souter. I think more than any other justice up there, David Souter, who after all was a Republican nominee, really tried to honestly weigh the legal arguments separate from the results that those legal arguments went to. He did not look at results first. I think he looked at the abstract principles involved to try to come to the decisions that. Now, there are times when I think some of the conservatives really take their adherence to originalism seriously. They've done it in some criminal law cases, where they've created some criminal law protections that you might not think are necessarily consistent with their political principles. Those are the exceptions and not the rule, and what we've seen from the conservatives, unfortunately, more often is a kind of very manipulable originalism that allows them to reach the result that they reached in Citizens United, or allows them to reach the results that they reached in Adirond, which is a case striking down federal action. It seems that originalism really doesn't get in the way when the conservatives want to reach certain political outcomes.
All right, next question we have here is, general thoughts on a constitutional amendment for privacy as a help or hindrance given the changing understanding over time?
You know, that's interesting, because if we just created a First Amendment, a constitutional amendment saying the right of privacy shall be protected, that's a classic example of what the framers did back in the 70s. They created constitutional amendments with very broad terms, understanding that times would change with respect to how that meaning should be. That would be true with a constitutional right of privacy. To be honest, I haven't thought about whether we need a constitution. I think that the court's wrestling on how to figure out what some of. Maybe we should take a look and see how the court begins to.
Very good. I don't think we have any more questions. That we want to thank Professor Marshall for giving us his time and you all for joining today's webinar. Make sure that you are around for the next webinar on October 5th at noon Eastern for Ted Shaw, professor at Columbia Law School. So thank you all for participating in today's webinar, and we hope to see you at the next webinar.
Thanks so much. Appreciate it.
Thank you.